Hi there, welcome. You have landed on the Disability Law Show again this week. Thank you so much for joining us. John Scholes right here beside me, Tamar Agopian, disability lawyer at disabilityrights.ca. You can always reach out. In fact, you should encourage to reach out to Tamar with any questions. And by the way, the consultations, if you need Tamar and her team, are free. So use it, 1-855-821-5900. The email to go with is help@disabilityrights.ca. I'll give those to you again throughout the show. As we carry on, we always get to phone calls, we get to emails. Tamar's got a lot to talk about this week, and we'll have a main topic this week. Love this one. What you should know about disability insured tactics. I'm liking the sound of that already. We're going to pull back the curtain a little bit on what insurance companies do, so stay tuned for that. But it's always a week that was, or a success story, a case you've been working on. Tamar, what do you got cracking this week?
Well, this week I wanted to focus on a topic that's come up a couple of times that we talked about in our group, actually. And it's a little bit, I don't want to say controversial, but it can have different views. I guess there was different views in our team about how to handle this. And it deals with travel. Travel while you're on disability, maybe after you were cut off disability. Does it change the opinion? Should you travel? Should you not travel? So for our viewers, I wanted to provide a little bit of context that most disability policies, the group plans is usually what we mostly talk about, have provisions in them that say, a section that limits travel. And what they're really after is that they don't want you out of Canada or perhaps the jurisdiction that you're in for more than, say, 3 months or 4 months, because it can impact how they pay you, because they're paying you essentially an income. So you can think of a world in which maybe they're paying you a taxable disability benefit that needs to be reported to the CRA, and they need to ensure that individuals are obtaining this in the jurisdiction in which they're getting paid. Well, at least that's the idea behind some of these provisions. But the reality is, as insurance companies will do, they like to use these kinds of terms as a way of demonstrating that you can do this or that. So if you can travel, it therefore must mean you have the function to work. Nothing could be further from the truth. Usually those two things are not the same at all whatsoever, but this does come up time and again. And it not only comes up while someone might be on claim, sometimes insurance companies will use the travel as a reason to deny, to say either you didn't get permission from us to go and travel, or you traveled even though your doctor told you not to, or some such thing, or you weren't honest about the travel that you were doing. And then it can come up after you're cut off, questions around, should I, now that I've got some time, should I be traveling? Should I be seeing family? Is this good or bad? And really what it comes down to, in my mind, not only is to check the policy to see exactly what it says, very important, but a close second to that is it medically endorsed? Because there's lots of situations where you can imagine someone's got a mental health disability, and that mental health can be greatly improved if they take a little trip. Perhaps they need to see family that's overseas. Yes, it can be difficult to make those arrangements and actually make that trip. But at the end of the day, if it's going to be of benefit to someone's recovery and it's made clear by the doctor or the practitioner that it should be done, then go for it. Then I never want people to feel like just because you're on disability, it means that you're housebound. That's not the test for disability. Totally disabled doesn't mean you're laid up in bed every single day. It means that your function is such disturbed by your health that you can't work and that you can't do your work duties. Doesn't mean you can't get in a car and maybe see your family that's 2 or 3 hours away, or perhaps get on a plane and go overseas and see some family, or do some other travel. But the policy terms are really important, the circumstances are really important, and the functional element, as I mentioned, is really, really important. Because if you've got, say, like this brings to mind a client that was recently talking to me about their inflammatory condition, and they've got a lot of conditions that are greatly improved in warmer climate. And we know most of Canada, right, John, we've got some poor climate going on, and especially these days. And you can see if someone travels to somewhere dry and warm, that can greatly improve their physicality. Perhaps they're accessing different treatment down there, and that becomes really, really important. And I never want to tell clients or claimants that this is something that's restricted, but the context is really important. And so this was the conversation I was having with my team. And one of the things that came up was this: the distinction about if you are restricted from travel after you are cut off. Here's what's important. After cut off, Our argument is that the insurance company didn't do right by you. They're not following their own policy to actually pay you. So if they were to be critical of you then traveling and potentially not abiding by their travel condition, well, they can't have it both ways. Either they're okay with it while you're on claim, and therefore they're okay with it after you're off claim, or they've got to be okay with it after you're off claim because they're not paying you anymore. So they're not bound by their terms and conditions of their plan, so why should our clients be? So technical, somewhat nuanced, but an important topic as we sort of get through the winter season, and we've got lots of viewers wondering, should I be doing this, should I not be doing it? Bottom line, if it's medically endorsed and you're going to continue your treatment throughout that time frame, then by all means, you should go ahead and travel as you need to in the context of your disability claim.
You mentioned medical endorsement. I mean, how far would you say the homework needs to go? For instance, if you're planning to go down south or spend, a week or two in Italy, calling me there. But if you're on disability or on claim, they're paying you. Should you be making arrangements, first of all, to get the okay from your doctor team, to arrange to have, if you need physio on site, wherever you're going overseas, have that arranged? I mean, you should have all these arrows in your quiver, right, to back up your thing, saying, look, I'm prepared, I can go away, but I'm still not going to be breaching my policy, right? Should you be doing all that?
100%. I mean, look, but that's the high watermark, right? Not everybody has the ability to make all of those arrangements. But I highly encourage to do that because, yes, you are then protected to the criticism. And they're cynical. Insurance companies are absolutely cynical. They're going to cherry pick information. Travel is one of those things that they get very hot and bothered over, rightly or wrongly, I think wrongly. And I think that if you can get your ducks in a row and have all of that arranged, then if there is going to be issues down the road with either ongoing payments or getting cut off over something like this, there's ammunition.
Yep.
Someone like myself, someone on our team can then point the finger to the insurer and say, hey, you got this wrong for X, Y, and Z. Here's the medical to back this up, and you should be paying my client some money.
PocketDisabilityLawyer.ca, good website, been around for a while, helped a lot of people. What do you think about it?
I mean, I really, really like this tool. I like it because it's super easy to use, very straightforward, no legal terms. There's a drop-down menu, and you can get a quick way in finding out what are my legal rights in the context of a disability claim. And if you want to contact us afterwards, great. But if you don't and you don't want to speak to one of us, that's totally okay. It's absolutely anonymous. So you close out your browser, you're out of it, but at least it gives you somewhere to start to figure out what are my rights in a context of a disability claim and what's going on with my insurer.
Got a couple minutes before we have to take a break, so since we have that time, let's get to our first phone call of the show. Listen up.
I applied and was approved for long-term disability. After I had a stroke, I was permitted to return to work after about 8 months, but I'm really struggling. Along with some physical ailments, my mental health is really suffering. Would I be able to resume benefits if I had to go back on leave, or would I have to reapply?
Great question. What do you think?
It is a great question because it is confusing when you've sustained something so serious, and then now you've got to deal with your disability insurer, but you've also attempted to return back to work, and you're seeing that perhaps you're not recovered in the way that you thought you might. And our caller tells us that he's experiencing mental health conditions. Again, not surprising. And now you've got some physical issues and some mental health issues together that's creating what we call a constellation of symptoms rendering someone disabled. And so in theory, no, you should not have to reapply if you're within a window of time that most policies, it's either called interrupted periods of disability or a recurrence provision. Usually it's a 6-month window from when you were stopped disability benefits, so in this case, perhaps when he returned back to work, to the point where these health issues recurred or there's other health issues on the horizon that then prevent this individual from working again. If that window of time is usually within 6 months, then you don't have to reapply. You would simply just submit more medical information, hopefully around the mental health part of it, because it seems like that's probably the more emerging, the more present issue. Submit that to the insurance company and say, my doctor has now advised that I stop working, and therefore I am in need of my long-term disability benefits again. If you're within that window of time, in theory, there's no waiting period and you are within recurrence. But what if you're beyond that window of time? Then potentially, yes, you do have to reapply. Depending on how long the return to work period was, it could effectively reset the clock. So then you have to go through short-term disability benefits or EI sickness benefits, depending on your setup with your employer. And then you have to go through that process and reapply for long-term disability. Bottom line, though, whether you're reapplying or submitting information to get your benefits kicked back up again, the medical information is critical in situations like this. It can't just be that you're too tired or you don't want to work or there's an excuse to not work or there's work issues. It has to be a medical question. It has to be supported by the doctor, because otherwise it's too easy for the insurance company to do what they probably did the first time, which is, ooh, this guy is ready to return back to work. Let's push him back. And he'll be just fine after sustaining a stroke, no less. And they win, right? Because either way, you're back at work, they don't have to pay you. They can resist your return back on the policy. They don't have to pay you. But they can't ignore the medical information. And certainly, if they resist this kind of return, this is what we're here to do, is to push the envelope and try and get the compensation for people, John.
Great stuff. We got to take a short break. And main topic on the other side, what are some tactics disability insurers implement? Oh, we'll cover that off on the other side. Stay with us. More of the Disability Law Show is coming up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Alrighty, welcome back to the Disability Law Show. John Scholes here. Tamar Agopian with me as well this week, as she was most weeks. You want to reach out to Tamar, you can. Disability lawyer at disabilityrights.ca. And the phone number, right, 1-855-821-5900. Consultations free of charge. Don't let that hold you back. We always have a main topic every week, and this one's a good one. What you should know about disability insured tactics. A lot of these three points I'm going to bring up tomorrow give people a lot of heartburn, a lot of worry, a lot of angst. But we're going to clear it up. First one's got to be one of the biggest. And that is disability insurers often monitor your social media, or they'll hire a private investigator. That'll give you some stress, right?
So it will give you some stress.
Yep.
But just before we get into the topic, John, I want to just remind our viewers that I used to work for one of these big bad insurance companies, and we used to call this the toolbox that's available for insurance adjusters on the things that they can do to try and bring your claim to a close or cut off your claim or resist your claim, okay? And it's no joke, folks. They have a list of things that they can do. We're going to touch on a few of them. And the first one, as John mentioned, was they'll comb through your social media. They will get an investigator out there. Now, I want to give some further context, though, which is getting an investigator to come out and, and surveil you and take pictures and take video. That's rare. It's not as common as you would think. Why? Because it costs the insurance company money. And the adjuster only has a certain budget. And if they're looking at their toolbox and seeing what they can do, doing a comb through of your social media is faster. Sometimes the adjuster can do it themselves. They don't have to hire a third party to do it. And if you haven't privatized your social media searches and what have you, your social media platforms, it's easy to grab pictures, grab messages. I've seen even chains off of people's Facebook walls that are in an adjuster's claims file. So why do they do it? They do it because it's human nature. We're going to put our best foot forward on social media. A lot of people are going to track what they're doing. If they had a great meal or a certain activity, perhaps, like I said at the top of the show, perhaps you took a trip and took some photos, and generally you're going to be smiling and you're happy. And so this can be taken hugely out of context in any type of disability claim, whether it's a physical or a mental health disability or some combination of the two. This is a big tactic insurance companies use because, again, it's cherry-picking information that satisfies their agenda. They want to bring your claim to a close. They want to have evidence or something to suggest that either you're not being truthful or you're not sick enough or you've got the ability to do X, which means you can do Y and go back to work. And so this is a big tool that they use regularly. So how do you protect yourself? The key here really is don't give them ammunition, right? You want to be consistent and honest with the insurance adjuster on all of your activities. Anything that you're doing that perhaps could be taken out of context, you want that medical endorsement, and then privatize your platforms, right? Don't get tagged in things. Don't unnecessarily get involved and roped into conversations on social media that could be taken out of context if it is in a public setting. I know it is a very active way that a lot of us communicate these days, and I know it's important. I've got a lot of clients who are involved in blogs and other things that they feel really strongly about, especially with disability claimants and disability processes. But at the end of the day, having some privatization of your life can prevent the insurance company from doing what they're invariably wanting to do, which is to use this information against you.
Or if you have trouble controlling yourself, just go dark for a bit, right? If you have to. I mean,
I suppose, I think where I'm sensitive to it, John, is that if you do have, say, a mental health disability, there's so many great outlets that are available on these platforms for people that are coping mechanisms that I don't want people to feel that they can't access this just because they're worried about the insurance company watching them. These are not barriers, I guess, is what I want people to know from us representing you or fighting the insurance company. If they've used this kind of information to deny your claim or cut off your claim, these are not things that deter myself or anybody else on our team to take on these cases when the context is there, when the medical support is there. Then these things are just tools, again, that the insurance company is using to their greatest advantage, but it can therefore then be a good basis to say the insurance company, your tool was not used properly here, and you ignored all of the other medical information that my client submitted to you saying they could not work.
And quickly, before I go on to number 2, private investigator, we often say that if you're being above board, you're not going counter to what your medical advice says, you should have nothing to fear with someone, watching you. As much as we don't like it, right?
It's icky, okay? It's icky. We don't like it. But absolutely, if you're doing everything that's aligned with what your medical team is saying to you to do or not do, then having a surveillance or an investigator out watching you for 2 or 3 days, not a big deal.
It might help you if you're doing nothing wrong.
It might help you. It's not even doing something wrong or not or right. It's a question of if the only thing they see you doing is either getting groceries or going to medical appointments, it's actually helpful to you. They're going to see what your day-to-day is like, which is that there's not a lot going on. It's not that, you're bungee jumping or parachuting, and doing something completely at odds with what normally we would see. But it's also that, let's keep it into context, totally disabled doesn't mean that you are laid up in your home every single day. I cannot emphasize that enough. And so don't feel housebound. Don't feel like this is a common process. It's just helpful for our viewers to understand this is something that insurance companies will do and will regularly do if they think they're going to get some kind of smoking gun to cut off your claim.
Number 2, here's another tactic. They request assessments by doctors they hire, right?
Oh, I enjoy this one. Why do I enjoy this one? Because they have funds to do this, folks. They will put money behind these files if it means they can close it sooner, quicker, faster. And so they do 2 things. They will either send you to their own rehab facility, rehabilitation, have you assessed, put you through a few tests, and have that provider give them a report on you can do a sitting down job, you can lift and still be okay to go back to your work. You're interacting with us and you can write a few tests, and so cognitively you're doing okay. And that then feeds into them closing out your claim on that basis, saying, well, our provider said you're just fine. So that's one strategy. The other strategy is they get you assessed by one of their experts. This is called an independent medical examination. One of the biggest misnomers in disability litigation, because it's not independent. They are actually quite literally paying the doctor to answer 2 or 3 very specific questions on how you're doing, how sick are you, and can you work? And at the end of the day, these doctors and practitioners, They know who pays their bills. They know that they can have continued funds coming from these insurers if they give them the right answers, the answers they need to then close out your claim. The trouble is, 99% of the time, most of your policies will say you are required to participate in these kinds of assessments. So really, the best way to protect yourself is try your best, attend the assessment, but then make sure that you're protecting your own medical information, make sure it's up to date, make sure there's context on, well, what happened at day 2, 3, or 4 after the assessment was done? Were you laid up in bed every single day because you were in so much pain after the testing they did? Were you cognitively compromised? Were you further depressed? These things should be documented and then supplied to the insurance company as the context, because guaranteed they're going to take these assessments and then use that to try and bring your claim to a close.
We'll get to one more of these tactics that the insurance company use, and that is this: they may delay your claim over and over, hoping that you're just going to give up. Not enough.
You know, and the delay tactic is so well documented, John, in the court decisions that it is highly improper. It's improper to do it in a legal context, and certainly it's improper doing it while you're being adjudicated, while your claim is being reviewed. But they are hoping you're going to give up because either they're not paying you or they're delaying the payments. They use that as a bartering chip to get you to do things like these assessments, maybe to get some more ammunition, to then at the end of the day try and end your claim. They might suggest to you that, well, we need more medical, and then more, and then you're at a point where your medical team is exhausted, you're exhausted, you've run out of funds potentially, and all you want to do is say, okay, well, I guess I'm going to have to go back to work. And nothing could be further from the truth if your own practitioners are saying that you should stay off. If the decision there is medically it's best for you not to be working, then the delay tactics really should be curbed if you hire us. There are strict rules around when they're supposed to respond to us, when certain things need to happen. And I cannot emphasize enough how powerful it is to start a legal claim, have a good legal team behind you. This nonsense will end, and we can then leverage this back to the insurance company to say, you didn't act in good faith. This was all the cards were stacked against our client. The information you received was biased. And at the end of the day, your wrists are going to be slapped if you're getting in front of a judge and saying, this is how we justified cutting off this person's claim.
And that is how we do our main topic every week. We got to get into one more short break, and we'll come back with some more emails. So stay tuned as we roll on more of the Disability Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back, Disability Law Show. Thank you so much for hanging in through the break. A reminder, always reach out to Tamar and her team. Toll free, of course, the number 1-855-821-5900. And the email to go along with that is help@disabilityrights.ca. That is what Greg used. We'll get to Greg's email first here. Tamar goes like this: my short-term disability claim is being transitioned to long-term, but I'm worried. My employer recently switched to a new insurance provider, and I've heard they're difficult to deal with on disability claims. Since I was already approved for short-term STD, do I have a better chance of being approved for long-term?
There's a lot here to unpack.
Sure.
And I think the short answer is that should there be a better chance of getting approved for Greg? Yes. In theory, and I want to start with the last point, I'm going to go back and make a couple of more points. In theory, it's the same test to qualify, and so it should be seamless. You should transition from short-term to long-term without any bumps. Sometimes it's even the same insurance company. If it's the same test to qualify, same medical support, then you should go from short-term to long-term without an issue. But it can be bumpy because You are going to get a new adjuster. You may have the insurance company actually paying you the long-term disability benefit, whereas perhaps before in short-term, it was your employer paying you. Insurance company doesn't want to pay you. This is the theme, right, folks? And so, yes, there could be a challenge in having your disability benefits and claim reviewed again with a fresh set of eyes with an insurance company who's motivated to not actually approve you for long-term so they don't have to pay you. But if they don't, and it's the same test, that is a massive problem for the insurance company. And so I'm hopeful for Greg that that transition will be seamless. And this is why I said, in theory, it shouldn't be a problem. But if it is, then by all means, this is where we get involved, because we can use these tests to say, wait a minute, it was okay for short term, and now all of a sudden it wasn't okay for long term. That's a problem for you, insurance company. But I want to make a couple of other key points. One of the other things that Greg said to us was, there's been a change in carrier. The insurance company has changed through the process of me going through this transition of short term to long term. That's an easy one, Greg. It should not impact your disability benefits at all. Your claim was crystallized. Your disability started when it was insurance company number 1. It doesn't matter if then it's insurance company number 2 with your employer, perhaps your colleagues at work. For you, you're effectively stuck with insurance company number 1, which from the sounds of it maybe is a good thing, because insurance company, he says, number 2, I hear, is difficult. It doesn't matter. It would only matter if you return back to work, you reset that clock, then the coverage would be with a new insurer. But if your disability crystallized already with insurance company number 1, then that is who will review and adjudicate the claim. The last thing I'll say is that in this type of transition, it does become really important that all of this documentation is refreshed. Don't rely on just the information that you submitted for your short-term claim to then hope and pray that you're just going to automatically be approved for long-term. This is a good time, because it's usually 3-4 months down the road, to actually get those updates. Get ahead of it. Even if you're not having to submit a fresh application to the insurance company, so new forms, fresh forms, it is a good time to get an update from your doctor, maybe a brief medical report, maybe some clinical notes that you can then submit to the LTD insurer as they're reviewing this to make sure that your benefits are uninterrupted through this whole time frame.
Is there a time delay between all this, or like you said, it should just slide over quickly?
It can.
Right.
It can. There can be gaps, because sometimes, in theory, the short-term period should dovetail nicely with the waiting period with long-term. So short-term ends and then long-term begins. But some employers have a gap. And I actually just had a call with someone yesterday who said, in my situation, I had to use sick leave credits, then I had to use EI sickness, then I had to apply to long-term, and by the time long-term kicked in, it's been 3-4 months, and I wasn't approved, and I haven't received my income. And so, in theory, it should be seamless, but sometimes people reach hurdles because of the way the setup is between short-term and long-term with their employer.
Does your doctor generally have to do a whole new song and dance, or just kind of transferring of files?
Again, it all depends,
Right.
case by case. It sounds to me like for Greg's situation, he doesn't have to do the whole song and dance. Right. But if you do have to apply to a different insurer, then you have to complete all of those forms again. You have to go back to your doctor and make sure all of it is completed consistently, and then get copies of all of it. Doesn't hurt to get your short-term forms resubmitted to the long-term insurer. The same information will be available there. And then if things have evolved and clearly it's getting worse because you're not returning back to work after short term, you want all of that information also captured in any of that new information that you're submitting, so that you can ensure that you get your long-term disability benefits approved.
And that will do it for this week. You may have a little bit of homework to do, but maybe not going forward. Always reach out to Tamar and figure that out for sure, unequivocally. 1-855-821-5900, help@disabilityrights.ca. Do one, do both. There's no charge for the consultation as well, so reach out as soon as you can. Thank you so much. We'll catch you next time on the Disability Law Show.